of our patent system is transparency. In exchange for limited exclusive rights, inventors disclose their invention to the public, benefiting society as a whole. Same fundamental principle of disclosure should extend to ownership information about a patent. But today, there's no requirement that ownership information be publicly available after a patent issues. So the bill that Senator Tillis and I have put in is very simple. It's very straightforward. It requires a patent owner to record updated ownership information with the patent office when a patent changes hands. The information will be made publicly available and searchable in a database maintained by the patent office. To ensure compliance, the bill provides that patent owners who fail to record ownership information in a timely manner cannot obtain enhanced damages for the period in which the information was not recorded. Our bill also requires the disclosure of government funding of patent application and maintenance fees, a language that came at the suggestion of one of our witnesses today, former Patent Office Director Dave Kappos, who's here with us. So this is important legislation for a number of reasons. Many of us in both parties on this subcommittee have heard horror stories about small businesses, entrepreneurs being forced to engage in costly litigation just to discover who exactly is accusing them of patent infringement and other claims. That shouldn't be the case. You shouldn't have to drain resources into expensive litigation just to discover who's suing you. And the lack of clarity about patent ownership information also brings about inefficient licensing discussions. They are important issues to solve, but of course they're not the only reason we should pass this bill. We are continuing to see that the competitiveness of American companies is at stake. Today, we know that 52% of U.S. patents are issued not to American companies, but to foreign entities. What we don't know is what happens to patents after the issue. It's critical information. Competitors like China are making serious efforts to increase their holdings of U.S. patents. In fact, China recently directed its centrally owned enterprises to double their holdings of U.S. and other foreign patents by 2025, to double them. Over the last 2 years, Huawei received an estimated $1.2 to $1.3 billion in patent licensing fees from an unknown number of patents covering an unknown array of technologies. As America positions itself to compete with China over the technologies that will drive our future, such as 5G, we simply have to know how much that intellectual property is in the hands of other countries. Greater transparency in patent ownership can play a vital role in showing the efforts of our competitors are taken to gain an economic edge over us. That's why Senator Tillis and I first proposed this legislation as an amendment to the U.S. Innovation Competition Act earlier this year. At the time, we worked with members of this subcommittee and Chair Durbin to reach an agreement on language that was ultimately cleared for inclusion in that bill manager's package. Now, while that package was not adopted, I appreciate the good faith efforts of the chair and others to work with us, find a solution that would result in greater transparency. Of course, since that time, we've worked closely with stakeholders to make improvements to the bill that resulted in the legislation we introduced last month. And as we consider this legislation, I welcome input from the patent community and from members of this subcommittee. In fact, hearing from stakeholders is part of the reason I was able yesterday to release Appropriations Committee language to ensure the Patent Office will be able to access all the fees it collects after an unfortunate proposed reduction in the Patent Office's budget for the coming fiscal year. So what we want to do is arrive at an end product. We want something that, like providing the Patent Office access to all the fees it collects, get strong support on both sides of the aisle, shine more light on patent ownership. I've long believed we should hear what everybody else wants to say, and that's why I look forward to hearing our witnesses today. I think transparency is a core tenet, not just our patent system and our democracy itself. I've worked with Republicans and Democrats to improve that. So I hope we can bring a little more transparency with this hearing. And I know Senator Tillis, as he told me just a few minutes ago, had looked forward to being here to discuss the bill. And I appreciate his and Ranking Member Grassley's willingness to say, go ahead and continue, even though they have to be absent. And of course, I will talk with both once we're done. So our first witness, who I believe is going to be appearing virtually, am I correct? That'd be Alan Datinski, the Senior Vice President, Chief Deputy General Counsel of the Law and Policy Group at Intel. Mr. Datinski leads the Intel Legal Department, an organization of approximately 500 legal professionals. He had been Director of Patent Litigation, served in several Deputy General Counsel roles, also practiced at the law firm Latham and Watkins, received his bachelor's degree from the University of Colorado, his law degree from the University of California, Hastings College of Law. So, Mr. Datinski, if you're on, let's go ahead.
Good afternoon, Chairman Leahy and members of the committee. Thank you for the opportunity to address this important topic. Right now, the American public has no way of knowing who the true owner of a patent is. This lack of transparency gives an advantage to opportunistic bad actors who are weaponizing our patent system and leaving American businesses and inventors vulnerable to attack. The current imbalances in our patent system undermine American innovators and expose the U.S. to economic and national security risks. The Pride in Patent Ownership Act is an important step to restore balance to our patent system. Intel routinely places in the top 10 annually of worldwide spenders in research and development and in the number of patents granted by the United States Patent Office. We're incredibly proud to be a leader in innovation and proud to let the world know that we are clearly listed as the owner of our patents. Public disclosure is the bedrock of our patent system. Just as a patent must disclose the claimed invention to the public, so too should it disclose who actually owns the patent. Intel is the only leading-edge U.S. semiconductor company that both develops and manufactures its own technology. We have many semiconductor factories in the United States, and we're currently expanding our manufacturing footprint. We directly employ more than 52,000 people in the United States, and our broader economic impact supports over 721,000 jobs across the country, contributing over $102 billion to the U.S. GDP in 2019. Greater transparency in patent ownership will result in numerous benefits to the public and our innovation economy. Today, I want to focus on one of those benefits: combating the rise of investor-funded litigation and the mass aggregation and weaponization of patents by investment entities, often foreign entities, against American companies. The integrated circuit was invented in the United States over 60 years ago, and for decades, America led a vibrant worldwide industry of dozens of semiconductor manufacturers. However, as the complexity and cost of semiconductor manufacturing has skyrocketed, many companies exited the industry, and today there are only 3 leading-edge manufacturers left in the world. Intel is proud to be the sole leading-edge semiconductor producer left here in the United States. However, the companies that exited the industry or ceased manufacturing possess vast arsenal of tens of thousands of patents that they no longer need to protect their own businesses. These patents are scattering to the wind, going to the hands of well-funded professional litigants around the world who target successful domestic industries with the objective of securing outsized financial returns. It is a perverse result that the patents which were intended to promote innovation are now being used to stifle American innovation and investment. The scale of this phenomenon is absolutely staggering, and yet the flow of patents between owners is essentially a black box due to the current lack of transparency in who actually owns a patent. Abusive patent litigation is not limited to the semiconductor industry, and it impacts companies small and large in virtually every industry. While the U.S. legal system is intended to dispense justice, hedge funds and other players in the rapidly growing industry of litigation funding have used loopholes in our legal system to hijack our courts as a tool for securing outsized investment returns at the expense of legitimate American businesses and innovators. They are buying massive numbers of low-quality, overly broad patents from failed or bankrupt companies, acquiring distressed assets for pennies on the dollar. They use sophisticated investment diversification strategies to deploy waves of predatory demand letters and lawsuits against small companies. And then they use the proceeds from those campaigns to fund high-dollar, bet-the-company lawsuits against big companies. For these investment entities, lawsuits aren't a byproduct of their business. The lawsuits are the business. The lack of transparency also poses a clear risk to economic and national security. Foreign competitors acting through a sovereign wealth fund or a private sector entity like a foreign hedge fund are making targeted investments in litigation funding, undermining critical U.S. industries like semiconductor manufacturing. Indeed, Intel has been the victim of patent lawsuits filed by mass aggregators supported by both foreign governments and by foreign investment entities who also own our competitors. Investment-driven patent litigation has moved from being a nuisance to a menace, and we need to take action now. While the Pride in Patent Ownership Act won't solve all these problems, it will go a long way towards helping us identify the scope of the problem, and it's a necessary first step in reining in these abuses of our legal system that hamper our economic growth and harm our national security. Thank you again for allowing me to testify before your committee today, and I look forward to answering any questions the committee may have.
Thank you very much. And we'll go through all the witnesses and I'll ask questions. Ms. Abigail Rives is the Intellectual Property Counsel at Engine. It's a nonprofit focusing on research, policy, analysis, and advocacy. I understand you work with thousands of startups across the country. Prior to joining that, Ms. Rives was an associate at an international law firm where she represented both defendants and plaintiffs in patent and trade secret disputes. She received her law degree from Emory University School of Law, and as I know, she clerked on the Federal Circuit. Please go ahead.
Thank you, Chairman Leahy, and members of the subcommittee for inviting me to testify today. Engine is a nonprofit.
Bring the microphone just a little bit.
Can you hear me? Is that better?
Yeah, there you go.
Thanks. Thank you for inviting me to testify today. As you noted, Engine is a nonprofit that bridges the gap between policymakers and thousands of high-tech, high-growth startups across the country through research, policy analysis, and advocacy. Right now, there is a lack of transparency in patent ownership that has opened doors to abuse that harms startups and small businesses. Bringing greater transparency would discourage abuse, reduce wasteful spending, equip startups with valuable information, and inform innovation policy. Your efforts to promote transparency will contribute to a patent system that works for all stakeholders, including startups across the country and the broader public. Starting off with one startup's experience. Ken Carter, general counsel at Bitmovin, recently told me about their first experience with a patent assertion entity. He said, "While we did our homework, the truth is that we got lucky because by chance we interviewed an attorney who knew the owner behind the LLC suing us. This attorney had litigated against a different LLC controlled by the same person. Being able to link the two entities gave us what we needed to respond in a way that got the lawsuit almost immediately dismissed." And Bitmovin's CEO, Stefan Lederer, added, "If that lawsuit had come 6 months earlier or 18 months later in the middle of a fundraise, it could have been an end-the-company event because no venture capitalist wants to invest in a company being extorted by trolls." Public notice is central to the bargain of our patent system. Patent ownership should not be an exception. Indeed, startups stand to benefit when others know with confidence that they own high-quality patents. As Rachel Lampkin, an IP attorney with almost 2 decades of experience representing early-stage tech companies and small businesses, put it, when someone starts a company, we get to see who owns it. It is a very odd thing that you have owners of a government-granted patent right, yet no one can see who owns that. Likewise, when it comes to things like patent clearance, licensing, and litigation, the details of who owns what are critical. As Jean Ann Booth, CEO of Unaliware, a medtech startup that advances safety and independence for vulnerable populations, recently told me, the whole purpose of patents is that you are putting information out there so others can learn from it, build from it, license it. If you could actually reach out to someone with a patent and tell them, hey, I want to pull your great idea into the work I am doing, as opposed to waiting for them to find and sue you. Importantly, abusive patent litigants can do more damage to startups when they conceal information about patent ownership and control. First, hiding behind shell companies is a common tactic that enables abusive patent assertion. An example can help illustrate this. In 2012, Project Paperless was sending letters to small businesses across the country. Based on a claim that anyone using an off-the-shelf scanner infringed, Project Paperless wrote demanding about $1,000 per employee. But a few companies realized they were in the same boat and decided to fight back. Websites like Stop Project Paperless popped up. That site provided details about likely invalidity of the patents, the assertion campaign, and the attorneys behind it. From then on, someone who received a demand from Project Paperless was only a few clicks away from learning these were dubious accusations. So Project Paperless then unloaded its patents and created into a newly created holding company, MPHJ. And instead of sending over 16,000 demand letters on its own letterhead, small businesses were hearing from Acnum, AdsPro, Interpar, or one of MPHJ's more than 80 newly created shell companies. While public awareness would make it harder for this campaign to continue under the Project Paperless name, once there were dozens of new names, the same patents and accusations could carry on, even though the MPHJ patents asserted in those cases were later found invalid by the PTO. And we just heard many others engage in similar tactics today of obfuscation, including massive hedge funds that are funding patent assertion entities and creating shell companies for assertion. Anonymity is enabling abusive tactics that prioritize volume and disregard the merits. Knowing who is behind those assertions would be useful to small businesses in the court of public opinion and beyond. Second, concealing patent ownership helps patent assertion entities avoid liability for vexatious behavior. For example, with fee shifting. Plaintiffs litigating very weak cases in an unreasonable manner are effectively judgment-proof if they file cases through shell companies. This tactic also helps avoid consequences under state laws enacted to address abusive assertion. Vermont and North Carolina are among the many states that have passed such laws, but those only work if you can see who is in violation. The state of Vermont received complaints from businesses and nonprofits, which prompted it to sue MPHJ. And a North Carolina packaging company is currently suing Landmark, alleging baseless assertion of infringement against it and other small companies. Simply put, allowing bad actors to hide patent ownership enables abusive conduct and frustrates the ability to deter baseless litigation. Third, as I've detailed in my written testimony, lack of clarity around ownership creates protracted headaches around standing, which can drive litigation costs further out of reach for startups. Defending even a lower stakes assertion entity case costs about $1.8 million, which is more than the average seed stage startup raises to cover its entire operations for 2 years. To sum up with another reflection from Ken Carter, this is the type of law we needed 3 years ago. This information would give us some of the tools we need to protect ourselves from low-quality patent assertions. Thank you again for inviting me to testify today. We very much appreciate your efforts to bring greater transparency to the system and are grateful you're giving tech startups a seat at the table.
Would you just repeat that $1.8 million figure again?
Yes. Just defending against a lower stakes assertion entity case costs $1.8 million, and our research shows that the average seed stage startup raises $1.2 million to cover its entire expenses for 2 years. And that's a pretty wealthy startup.
Thank you very much. Our next witness, Professor Robin Feldman, is the Arthur J. Goldberg Distinguished Professor of Law and the Albert Abramson 54 Distinguished Professor of Law Chair at the University of California, Hastings Law, where she's also the director of the UC Hastings Center for Innovation. The professor has published 4 books, more than 70 scholarly articles. I know she's testified in Congress before. We've seen her testimony in the congressional record and cited by the White House in various governmental reports. She received her bachelor's degree from Stanford University, a law degree from Stanford Law School, and clerked on the Ninth Circuit. Professor, please go ahead.
Mr. Chairman, esteemed members of the committee, it's an honor to be here today. Mr. Chairman, as you pointed out in the opening of this hearing, American capitalism is founded on the precept that markets should be open and free. In this spirit, and going all the way back to the first Patent Act of 1790, Congress determined that notice and disclosure are essential tools for encouraging innovation and making innovation markets fair, transparent, and efficient. Patents are quintessentially a notice system. If you want to make a product, you're supposed to be able to look through the patent office files, find any patent rights that might be implicated, and then show up on the patent holder's door, hat in hand, asking for a license. You are not expected to dance in the dark. And when a patent holder provides that information, it's part of the quid pro quo for receiving this extraordinarily valuable patent from the government in the first place. Over the last 15 years, however, patent markets have begun to resemble the Wild West with no sheriff in sight. So new types of large and complex entities have appeared on the scene, some of which hold their patents in thousands of different shell companies in order to hide ownership and avoid liability. Now, these shell companies exist in hidden network relationships with the parent company. The problem is, it makes it very difficult for those who receive a patent demand to challenge the validity of the underlying patent. If you can't figure out who controls the patent, you can't bring them into court. In addition, many ordinary companies now place their patents in foreign subsidiaries as a tax avoidant strategy. So given the scramble to create shell companies, limited liability companies, foreign subsidiaries, basic information about patent ownership and control is getting lost in the stampede. And to put it very simply, shell games and hide and seek rarely make for a fair and efficient marketplace. A company doesn't have to be a massive entity to wreak havoc on unsuspecting people and small businesses. Working with just 5 patents, one company created more than 100 subsidiaries, sending thousands of demand letters to small businesses. When the target is a small player like that, who has very little knowledge about the patent system, it can end up making multiple payments to what's essentially the same entity when it already holds a license, or it may not have needed to take a license in the first place. A small business just can't afford to spend a fortune playing detective, and the patent system shouldn't ask them to do so. It's even more challenging for those who are trying proactively to do the right thing. For example, trying to understand if they need a license and whom to approach. They cannot rely on patent office information because, as my research has shown, patent holders are able to transfer ownership without full and timely disclosure. But even when ownership information is available, that's just the tip of the iceberg, because patent owners can transfer enough of the right for someone else to assert the patent without formally transferring ownership. Thus, understanding the money flow can be an essential part of understanding who is actually in control. We have similar issues that come up with stock ownership, and we know how to solve them. We should be able to find analogies here as well. Transparency is particularly appropriate here because patents are government-conferred grants. Society should never tailor a government system in a way that encourages information asymmetry and economic distortion. And of course, processes that allow people to take advantage of and dupe the small player are inconsistent with the fundamental goals of the American patent system. And finally, information on the identity of who holds interests in patent rights is important from another societal perspective, because currently we have no way of knowing the extent to which foreign entities control our intellectual capital. These are the crown jewels of our country's economic system, and it would hardly be in the nation's interest if our intellectual capital becomes largely controlled outside the country. And yet, we have no way to know if that's the case. In short, as Justice Brandeis once famously said, sunlight is the best of disinfectants. I look forward to answering your questions. Thank you.
Thank you, Professor. And I think you find very strong support across the board in our committees about concerns of our patents being held overseas. No matter what the country is, we know that at least one country is trying very, very hard to corner the market. The next witness, David Kappos, a partner at the law firm of Kravis, Swain and Moore. But for this, especially for this committee, 2009, 2013, he was Undersecretary of Commerce, but director of the U.S. Patent and Trademark Office. I know I spent a great deal of time with him as we were writing and implementing the Leahy-Smith America Invents Act, which was the first real overhaul of our patent laws in about 50 years. And of course, he spent, prior to his service in government, 25 years at IBM and various executive posts in the company's legal department. Bachelor's degree from University of California, Davis. Law degree from University of California, Berkeley. And somebody most of us know very, very well. So it's good to have you here again, Director. Go ahead.
Well, good afternoon, Chairman Leahy and members of the Subcommittee on Intellectual Property. Thank you for introducing this legislation and for offering me the opportunity to provide my views on patent ownership and funding transparency. I am testifying today solely on my own behalf. Patent ownership transparency is a topic that I have been keenly interested in going back to when I was in corporate practice and found it frustrating to discover patents my client may have been licensed to or may have wanted to seek a license under, but not knowing who owned them. The issue has become more acute in the intervening years, and there's a new issue, state actors paying for the filing of patents that may exclude 330 million Americans from access to technology without visibility to those actors. When I was at the USPTO, we studied patent ownership transparency, initiating outreach on actions for the government to increase transparency. And in the years since, I have participated in a global effort to increase patent ownership transparency through a UK-based nonprofit called Oropo. Oropo member companies voluntarily disclose their ownership interests in patents. This global effort recognizes that patent ownership transparency is a problem impacting innovation worldwide. And participation by major companies in Oropo demonstrates that it is possible without major burden for patent owners to make such disclosures. So I'm pleased to see this legislation signaling that the time has finally come for patent ownership transparency, and I'm pleased to see the U.S. leading. This is an opportunity for us to once again set the gold standard for the global IP system. Now, turning to the legislation itself, it covers the essentials well. Requiring disclosure of ownership interests in patents will enable the public to understand who owns what, whether those owners are domestic or foreign, small or large. I applaud the disclosure requirements for patent filings funded by government actors and the paired grant of authority to the USPTO, enabling it to ensure we understand the extent of foreign government actor influence on our patent system. I especially like having the USPTO determine what creates an interest requiring disclosure. Given the need to reach beyond mere ownership and address control, not necessarily cabined to ownership, the approaches used by CFIUS and others who've previously considered these issues will be beneficial. The above being said, I'd like to now discuss some aspects of the bill that can benefit from further refinement. Crafting consequences for noncompliance is challenging, but the penalty, loss of recovery for willful infringement, doesn't seem connected to the requirement. It has the unfortunate consequence of rewarding the most egregious infringers with a windfall. If the willful infringement penalty is retained, one approach in seeking balance and fairness is to require the willful infringer to show it was actually prejudiced by the lack of disclosure before receiving the benefit of relief from willful infringement consequences. It would also be constructive to consider positive incentives in addition to negative ones. My experience with patent holders is that the vast majority operate in good faith and respond conscientiously to positive incentives. We've focused in recent years on penalties for patentees on the presumption that patentees are the main abusers of the patent system. We should move to a balanced posture, recognizing that parties on all sides of the system engage in strategic behavior and plenty of copyists take advantage of weakened patent rights to infringe valid patents. Instead of only penalizing those who do not record, the law could also reward patentees for recording ownership. While it is appropriate for the USPTO to devise implementation details, it is important for the bill itself to provide a North Star for the agency, specifying or specifics regarding the policy objectives and the purpose for the PTO's implementation. This will ensure mission clarity at the USPTO as it defines certain rights and interests in a patent triggering recordation. Chairman Leahy, members of the subcommittee, the time has finally come for patent ownership transparency. If helpful, I'd be pleased to assist the committee as it refines the bill. Thank you again for your efforts in this legislation, and I look forward to addressing your questions.
Thank you all very much. Let me begin, Ms. Rives, with you. The Pride and Patent Ownership Act has a remedy that we intend to encourage patent owners to comply without unduly punishing mistakes. When the patent owner has not registered her or his ownership, enhanced damages are not available in later litigation, but only for the window of time in which the ownership was not registered. So my question is, how often do courts grant enhanced damages now? And is the remedy a windfall for willful infringers or a reasonable consequence of failing to give the information about a patent?
Thank you for the question, Senator. To the first part of your question, I looked at a study recently that found that over the last 5 years, of the thousands of court cases filed in district courts across the country, only 158 of those decisions even considered willfulness and enhanced damages, and of those, only 31 total had awarded enhanced damages. So it's a very, very small number. But to the broader part of your question, I think that the proposed remedy here is a reasonable and balanced one. And I think there's something very logical, because what we're concerned about with willful damages is that somebody knew about the patent and knew what they were doing and did it anyway. And if there's a lack of information about who owns the patent rights, it kind of melts away some of the fundamental underpinning of willfulness. And I will also note that, of course, with the Pride and Patent Ownership Act, the patentee would still be able to seek reasonable royalties and lost profits and be able to made whole. So it's really just giving up that ability to push damages higher because it failed to make a public disclosure under the Act.
Thank you. And Professor Feldman, do you agree with that?
I do. Laws are only effective if there's a way to enforce them. So there must be something that has at least a little bit of a bite. And if the remedy is too complex and just sets off more litigation, it may not be helpful in the long run.
I think if you buy a house actually buy a car, in most states you have a requirement, you got to record the transfer of ownership, who bought it and from whom. Shouldn't it be something analogous if we, during patent transfers?
Absolutely. Houses, cars, shares of stock. If you transfer any of these assets, you're required to register that transfer of ownership with the government. It's part of ensuring a fair and efficient marketplace. We should certainly have the same for the patent marketplace.
Thank you. And the question I have, a couple questions for both Mr. Stabinsky, who is still on, I believe, and Mr. Kappos. Mr. Stabinsky, you mentioned in your testimony lack of transparency poses a risk to our national and economic security. Companies in other countries can buy U.S. patents without any way for the public to know. So I don't mean to keep pounding on the 5G network, but let's do so. We don't know the size of the royalties U.S. citizens would be paying to other countries to use basic American infrastructure. So what are the consequences for American competitiveness if we don't have more insight into what type of patents are being bought up by foreign entities? And I'll start with Mr. Stabinsky.
Thank you for the question, Senator. Well, the implications to American competitiveness are profound. And since you mentioned 5G, there was a recent study looking at the top 5G patent holders. Amongst the top 10 patent holders, there's only one American company. The single country with the largest representation is China, where 4 companies are there. 2 out of Europe, 1 out of Japan. But like I said, 1 out of 10 is an American company. And so you have to ask the question, who are those royalties going to be paid for? So we've answered that half of the equation. They're going to be paid to foreign entities from American companies. And then we ask, well, who are those American companies? If we look in the smartphone industry, innovative companies like Apple and Google. If we talk about connected PCs, Dell, HP, Apple. If we talk about connected cars, increasingly happening here. We talk about Ford, General Motors. And it's not just with respect to the standards patents where we talk about 5G and cell phones. We're seeing it firsthand in semiconductors, as I explained in more detail in my witness testimony, where we're seeing large amount of semiconductor patents being aggregated by foreign investment entities and foreign government-sponsored entities. And they're coming to America and they're taxing America's last standing leading edge manufacturer, Intel. And the proceeds are going offshore, Senator. That's a profound implication for American competitiveness.
I have other questions for the record, but I'll just one I would ask Mr. Kappos, do you have national security concerns stemming from lack of transparency around patent ownership?
Yes, thank you, Senator. I do. And they come from a number of directions. One is, again, lack of knowledge of who owns what patents makes it difficult to get licenses to them when you need to know how to challenge them, to know what your risks are relative to them. There's another component as well, though, that deserves mentioning, which is the possible instability of the funding source for the United States Patent and Trademark Office. One of the issues we face is with increasing numbers of filings coming from overseas funded by nation states, right? Those nation states typically will pay the cost to file a patent application and to prosecute it. As you know, that's a subsidized cost. Normally, that's then recouped by maintenance fees that are paid in 3, 7, 9 years out, but those foreign governments don't pay the maintenance fees. So in effect, they're taking a subsidy from the U.S. government, then they're not paying back the subsidy, potentially leaving the U.S. Patent and Trademark Office with tremendous funding deficits going forward. So that's an instability of the system that's going to come about here.
I thought you'd be the one that would be familiar with that. Senator Blackburn has joined us, and please go ahead with your questions.
Thank you, Mr. Chairman, and thank you for this hearing. I have to tell you all, I was just on the phone or not, I was doing a Zoom with some of our innovators in Tennessee, some of our creative community that primarily work in the music and film industry. And of course, intellectual property is a major issue with them, as you all can appreciate. And last week, I was up at a demonstration project we have at Oak Ridge, which is between University of Tennessee and the labs. And Mr. Kappos, am I saying your name right? Kappos?
Sure, that's fine. Thank you, Senator.
Well, I want to be sure I say it properly.
Okay, Kappos.
Kappos, okay. That helps, thank you. Let's talk about China. And there's a lot of concern about the subsidy measures around Chinese companies, and then their directed investment into U.S. companies, and a lot of concern around Huawei. And of course, Huawei's been criticized for their numerous yet low quality patent applications, and how China infringes in this entire process is of tremendous concern to our innovators, whether they are working on tool and die and next generation or new composites. And what I'd like for you to do is describe Huawei's involvement in the U.S. patent system, including the approximate number of patents that they hold.
So thank you, Senator. That's a great question. To get to that level of detail, I would have to answer by going back and doing some research for you. I believe
That would be great.
I'd be happy to do that. I can tell you directionally, it's likely they own thousands of patents in the
Okay.
U.S. But
That would be helpful, because as I talk, we have a significant auto industry in Tennessee, and you have LG and SK that are both doing big investments in our states with batteries for electric vehicles. And there is a good bit of concern around this and how China is trying to push in to some of this lithium battery components. And when you look at Huawei and the communication systems that are involved, people are really quite concerned about this and how they will capture that data, how they're going to really end up diminishing the value of U.S. held patents because they have infringed and done their own patent application. Let's see. Let me ask another question. The intellectual property issue. Let me go there because that is a problem for so many of our innovative industries. IP theft. And is it Ms. Feldman? Yes.
Yes, it is.
Let me come to you on that. Is this a major issue with the companies that you're in communication with, and what impacts do you see this having on businesses, especially businesses where their stock and trade and their valuation is held in intellectual property?
Our ideas, our innovation, our intellectual capital, these are the crown jewels of the American economy. It is extremely important that those not be siphoned off overseas by others who are not observing intellectual property rules properly. I know administrations have worked very hard to try to bring greater strength to bear on those issues, but it's tremendously important for American companies and for our economic stability.
Yes. Anybody else want to add something on the intellectual property theft?
Well, I could just perhaps add that the fear that I have is these technology transfers like out of Tennessee in the lithium-ion battery space. they tend to be in one direction. And so the foreign company comes in, it learns a lot from Americans in Tennessee. It takes that technology back overseas, and we never see it again, and it creates jobs and economic prosperity overseas. So that's I think where the concern in my mind goes, is a kind of a tech drain that's occurring.
Yeah, and I think a lot of this happens through the talent program and China's talent program, and they send people over and then they take the ideas back and monetize those ideas, undercutting the innovators that actually did that work here. So tightening up who we let into our research universities is probably a big part of protecting our patents. Thank you all. Thank you, Mr. Chairman.
Thank you, Senator. And Senator Coons, you certainly had a great deal of experience as chair in all of this committee. Go ahead.
Thank you, Chairman Leahy, and thank you to all of our witnesses. I do think it's an important conversation for us to be having today about ownership transparency, particularly with regards to ownership and the potential consequences of transfers in ownership in ways that disadvantage the United States. I do want us to also be mindful about not inadvertently harming U.S. Inventors or innovators in the process, and making sure that we're not weakening patent rights or creating administrative pitfalls for their proper enforcement, because I think we strengthen our global competitiveness, as you were just discussing with the senator from Tennessee, when we find ways to advantage and strengthen the rights and opportunities for innovation here in the United States. So Professor Feldman, let me start with you, if I might. You testified about the costs and the burdens, the balance of equities in this bill. This bill, the current proposed mechanism is to penalize patentees who fail to timely record by precluding willful infringement damages, increased damages for willful infringement. One argument that has been made is that rewards and encourages the very worst actors in the patent system, the most willful. Are there other ways we might provide appropriate incentives, such as incentives for timely recordation?
As I noted before, laws aren't helpful unless they can be enforced. Both positive and negative enforcement mechanisms, I believe, are helpful in the legal context. To cite an old adage, trust everyone but cut the cards. We do need a way to hold people's feet to the fire. This bill has chosen an area which, as was discussed previously, I believe is connected to the notion of willfulness. Full information, if there's not full information, it is difficult to hold someone willfully accountable if they don't actually have the information. And I believe it touches on a limited area of the patent litigation flow. But I do believe some areas must be there in order to hold people accountable with their behaviors. In terms of the cost, I'd simply say that there are always costs in providing information for the market, but those costs pale in comparison to the costs of economic efficiency when we allow hide and seek to happen. Thank you.
Director Kappos, you'd also made a reference about encouraging recordation. I'd be interested in your thoughts on whether or not it's appropriate for there to be some opportunity to cure where there's been a purely administrative error that has led to a timely recordation.
Yeah, sure. Thank you, Senator Coons. I'm happy to address that. First, if I could just momentarily correct the record on the issue of willful infringement. Willful infringement in the patent law has absolutely nothing to do with the owner of the patent. What's required for willful infringement is knowledge of the patent, not the owner of the patent. So we just want to get the record straight there. In terms of other incentives, what I go to is opportunities to reduce maintenance fees and opportunities to reduce issuance fees.
I mean, as a positive incentive towards timely recordation of the transfer of ownership.
Right, right. Going then to your question directly, Senator Coons, there are any number of instances in which mistakes will be found. One place I see it is in M&A deals, where after a client acquires a university-owned patent or a startup company that maybe wasn't very careful about keeping track of its ownership interests, you discover in diligence problems that they had. We should provide a mechanism in this bill to go back and fix those things in good faith, because the policy justification behind the bill, which I strongly agree with, is to keep the ownership records correct at all points in time. If that's the policy goal, you have to accept there will be mistakes, things will change. And so we need to build into the bill the kind of robust mechanisms that enable and incent parties, acquiring parties, the original party, whoever, to keep the records clear.
My understanding is the Patent and Trademark Office reported, I think it was 6 years ago, that the average time for recordation was about 180 days for transactions being executed. That's about twice as long as proposed in the bill. What are your thoughts on what's an appropriate timeline for an expectation of recordation?
Right. I do think it probably needs to be longer than what it currently is. I recall the PTO statistics that show that it takes a while to record. I also see in the real world of transactions and putting these recordals in place that many times changes come about as a result of larger transactions that have lots of moving parts in them. It becomes very difficult to record in a short period of time, much less if you're a small company or a startup and you don't have all the infrastructure in place. So I would agree, Senator Coons, that providing some additional time makes sense.
Last question. Do you think there's sufficient clarity about what the contours are of the rights or interests that should trigger recordation? And how do you think the Patent and Trademark Office might use discretion to delineate that?
Yeah, well, that's really the key question. So two things there. Number one, I feel like, as I mentioned before, some kind of a North Star, some kind of policy contours need to be provided in the bill. But then the hard work is for the U.S. Patent and Trademark Office, and they're going to need to get into the details. Does a relationship with an affiliate company trigger a recording requirement? That can get really complicated, and there are millions of those kinds of relationships. What about stock ownership? What about options? What about ROFRs, rights of first refusal, rights of first negotiation? There are myriad interests, exclusive licenses, sole and exclusive licenses, and we need to think through every one of those so that we can provide clarity so that parties, as you say, in good faith, can know what they need to record, but they can also know what they don't need to record.
And this will also make searching and clarity about chain of ownership and title and searching patent states more efficient in the future. Thank you, Mr. Chairman, for your indulgence. Thank you for your testimony to all the members of the committee.
Senator Rono.
Thank you, Mr. Chairman. I share the concern about the appropriate balance here, because I think that we are all in favor of more transparency as to who owns the patent, or even that there is a patent. But I do have a concern about the fact that some could argue that we are letting the worst infringers, the willful infringers, from the kind of liability that they should be exposed to. So I understand that the Patent and Trademark Office already voluntarily accepts registration. What percentage do you think, this is for you, Mr. Kappos, what percentage of patent holders are registering their patents voluntarily?
So there's a significant percent that register, and while I don't have statistics in front of me, I would tell you from experience there are already some pretty good incentives. So it's well more than 50%. It's a large majority. But, Senator Hirono, the problem that we found when we've looked at the accuracy of that recording is it's pretty spotty. There are plenty of errors. So that's why I definitely agree this bill is needed. The recordal needs to be accurate at all points in time, and it needs to be 100%. So 80%, if that's what it is, that's not quite good enough.
So the Patent Office would have to add additional resources to be able to truly support the patent owner's registration efforts.
So my sense is that while there would be some new tasks and some marginal new resources, the USPTO's got very sophisticated and capable IT systems. Since it's already got a recordal capability, the addition will be incremental in my view. And it's got a budget of, as Senator Leahy was saying earlier, well over $4 billion. So it can certainly manage standing up a new recordal system.
Do you recommend to your clients that they register their patents?
Absolutely.
So that, and you do that because it is actually to the benefit of the patent holders to do that.
Yes, you get advantages against subsequent recordals of interest from good faith purchasers.
So there are already incentives for registration. So the kind of system that this is putting in place where through some kind of clerical error, or if you're a small patent holder, in fact, that some of the discussion is that it takes some time to even have your registration showing up as having been registered. So since we already have what I understand are incentives for registering, then why would we want to put in place a kind of what I would say not exactly balanced a balanced situation if through no fault of the patent holder their patent isn't registered and somebody willfully infringes that patent and that person cannot get enhanced damages?
Right.
Is that going a little overboard?
Well, a balance is certainly a challenge, and that's one of the things that I've testified on here. And I do think there are ways to improve balance, including reserving the willfulness penalty for the most egregious parties who either flaunt the requirement or behave in fraud. But I do think the current recordal system while it's got some incentives, they're clearly not strong enough to cause all parties to record.
Well, my question really is that we can talk about the further incentives for patent registration, but is the incentive that if you actually can show that someone willfully infringed your patent, that you're not going to get the sort of enhanced damages that you are going to need to show that you are entitled to? Is that the kind of incentive that you think is appropriate?
Well, that's where I feel like the incentive isn't really very well matched, and would like to see and help with some more work to get the incentives to be more aligned.
I tend to agree with you. I think that if somebody is willfully infringing a patent, and that, by the way, Mr. Kappos, isn't that kind of a high standard to show willful infringement?
It is a very high standard.
And of all the cases that are brought, I have no idea what percentage of those cases that are brought against patent infringers that's shown to be a willful infringement. Perhaps the other two people testifying, if you'd like to weigh in.
Yes, thank you for the question, Senator. To your last point about the statistics, as I mentioned earlier, a paper written by Veena Tripathi in 2019 showed she counted over 5 years, 158 district court decisions of the several thousand filed between 2013 and 2018 reached a final decision on willful infringement. Of those, only about 62 found willfulness, and of those, only 31 awarded enhanced damages. So it's a very small number of the overall universe of patent litigation that gets to this question.
Well, except that if you're one of those people who you were able to show willful, because that could just mean that to show willfulness is a very high standard, and therefore not very many litigants can meet that standard of proof. So it could mean that. Anyway, my point is that I think we can find maybe other kinds of incentives for registering, which is something that I certainly would support, more transparency in who is holding patents. Thank you, Mr. Chairman.
Thank you very much, Senator. Senator Padilla, please.
Thank you, Mr. Chairman, for holding this subcommittee hearing. I'm thrilled to have such excellent California representation here today, and extend a special welcome to Mr. Datinski and Professor Feldman. Colleagues, California is home to a wide range of thriving industries, academic centers, and millions of consumers who rely on a patent system that encourages innovation to flourish throughout our economy. On the topic of today's hearing, there appears to be a general consensus that there should be enhanced transparency about patent ownership. After all, a patent is a government grant exchanged for the disclosure of adequate information about an invention. And if someone else wants to make use of that invention, it should be easy to know who to approach. I'd first like to focus on how this issue impacts startups and smaller companies who often operate on slim margins and have limited time and resources. It's important that we have an environment that allows them to successfully create and to compete. So, Ms. Rives, I'll begin with you. In your testimony, you highlighted that smaller companies and startups are particularly vulnerable to abusive patent practices when there is an asymmetry of information about the owner of a patent, and that our current system makes it difficult for startups to deal with patent clearance, licensing, and litigation. Would enhanced reporting obligations about patent ownership improve the ability of small businesses and startups to compete against larger businesses? And if so, why?
Thank you for the question, Senator. And I think the answer to your question is yes. So first, I think bringing greater transparency to the system, as you noted and I noted in my testimony, would reduce abuse of the system. And we know that startups that face litigation from non-practicing entities, patent assertion entities, suffer a great deal and can sometimes have to shut down. In addition, the ability to know who is accusing you of patent infringement can bring a great deal of value in terms of strategic response. And then I would finally note that in terms of competition, this greater ability to operate free from threats of abusive litigation and a reduction of that burden in the startup ecosystem, including in California, of course, would just bring greater vibrancy to smaller innovators.
Appreciate that, but want to ask an important follow-up because I can, hear folks who may disagree already. How can we be sure that additional reporting obligations aren't overly burdensome, right? That we don't go overboard by burdening small businesses and startups who seek to obtain or currently have patents?
Yes, thank you for the question, and I think that's such an important question. First of all, this recording your ownership with the PTO isn't a substantial burden, and I'll go into that in a bit, and as I noted, the transparency can reduce a lot of burden. We hear from tech startups all the time about burdens that they do face, and this just isn't on the radar. First, businesses have to comply with a lot of regulatory and legal requirements already. Transparency is very frequently a part of that, so they're used to participating in, for example, recording their business with the Secretary of State. Second, what we're talking about is updating information with the PTO. So if you're assigning a patent right, you've already got a contract, you've papered that up, and so we're talking about telling the public that you entered into that contract. I went through the PTO's online system for uploading that information this weekend. It took me less than 7 minutes, so that's what we're talking about here. And then third, there are very real barriers to entry in the patent system, and I would be very happy to talk with your office after the fact about things that we could do to lower barriers to entry in meaningful ways to reduce burdens for startups that want to obtain high-quality patents.
Thank you, and that would be helpful. And so in the spirit of striking the balance of my two previous questions, can you just offer a couple more examples? What kind of reporting and notice about patent ownership do you think would be most helpful to startups?
Sure. So I think first, as we've talked about already, I have confidence that the PTO, through rulemaking, would take a thoughtful and deliberate process to hearing from numerous stakeholders about what needs to be recorded. Things like assignment and actual ownership, I think, is contemplated by the bill and certainly makes sense. There are, as Mr. Kappos alluded to, some perhaps more difficult questions, and I think it will be important for the PTO to provide clear and consistent instructions to the community of patent owners so they know what they do and do not need to record. And then in addition to the transparency that could be recorded with the Patent Office, I think we would be interested in seeing other opportunities to bring greater sunshine into patent litigation, so not just issues of patent ownership, perhaps on down the line in another vehicle, thinking about litigation finance and other tools that are allowing really wealthy hedge funds to target, among others, startups.
Okay. Thank you, Ms. Rives. Thank you, Mr. Chair. Look forward to our ongoing work.
Thank you very much. I know with these kind of hearings seem like we go into the weeds, but the effect on our patent holders and I was thinking, Mr. Kappos, you and I have talked before about your concerns about foreign countries being involved, China in particular, and paying for patent applications, fees, and costs to file U.S. patent applications. You want to explain that a little bit more, your concerns about foreign countries and subsidizing U.S. patent applications?
Well, sure. Thank you, Mr. Chairman. So the way I would sum it up is that each patent, of course, provides the owner with the right to exclude all others from practicing the invention for up to 20 years from the filing. So each time a foreign government takes out a patent in the U.S., our whole country is potentially impacted by it. You can imagine diagnostics that can't go into the marketplace. You can imagine products that can't go into the marketplace. And not having transparency, knowledge of who owns that patent, right? A foreign government or a state-owned enterprise or a state-affiliated enterprise strikes me as being, very dangerous for national security, for the American people generally. And it's troubling enough when you're dealing with foreign enterprises that are hard to research, hard to figure out how they're related to one another, hard to figure out who runs them. It's even more troubling when you're talking about a huge government that is potentially able to exclude 330 million Americans from access to products and services.
Good. Thank you very much. And I might ask Ms. Rives this question. I'm trying to think of the registering and so on. Let's talk about patent owners who have to register to changes in ownership. How does that burden compare to the burdens placed on public or small businesses who have to figure out who they're negotiating with over patent licenses?
Yeah, thank you for the question, Senator. And as I just mentioned, the burden here to upload information with the Patent Office about who owns what patent is not very high. But the burden of being accused of infringement, of course, even in a demand letter, not getting to the cost of litigation, is very substantial for startups. They can put a cloud over their ability to fundraise, their ability to attract customers. And so there's a lot there. And I'll also note, I think, as Professor Feldman alluded to, the inefficiencies in the patent assertion system, the litigation system of at the point of assertion, trying to figure out who owns what are substantial. In a recent lawsuit, Unilock did not have standing to sue Apple, but Apple had to litigate for 2 full years to get to that conclusion, engaging in extensive discovery, and that's just something a startup couldn't afford.
Thank you very much. I know when I listen to it, some of the things that can involve those who get in the patent system. It's one thing if you're a very large company, even though you might get angry that you're being held up to 2 years you're talking about, but they have a major law firm, I might say, and it's cost doing business. I worry about so many of the small innovators, well, my state, your state, and the other one. And I know Professor Feldman is, along with others, that talked about diversity and access to the patent system, find out who's applying. Also gives us a chance to encourage more, whether you have representation of women or minorities, others historically underrepresented. I was thinking of a young inventor talking about what all she went through shortly after she graduated from Middlebury College in Vermont. And in fact, I had the opportunity last week to be having lunch with the president of Middlebury, and we were talking about this young woman and her innovation, all that she had to do. Now, you mentioned in your written testimony that the information can clarify the extent to which the patent system reaches a diverse set of inventors, and that I would hope would unleash American innovation and strengthen our economy. You want to expand on that, discuss the benefits of knowing who owns U.S. patents for the purpose of understanding the demographic and the geographic diversity of patent owners?
Thank you, Senator. Studies suggest that women, and women of color in particular, are seriously underrepresented in the patent system. Without additional data, we have no way of knowing the true extent to which these very valuable rights that the government is handing out are bypassing important segments of the population, important creative and important to this country in so many ways. Senator, if I could for 1 minute just return to the question of willfulness and the remedy, because that seemed to be much of the discussion in the hearing. Mr. Kappos suggested that willfulness is about the contours of the patent, which is true, but the contours of the patent are very difficult to determine, even for those of us who are steeped in patent law and love patents. Very hard to figure that out. Knowing who owns the patent, being able to engage with that party, seeing how that patent is being asserted, those are all part of understanding the contours of the patent. And that's why willfulness is a very reasonable way to reach trying to understand and deal with this openness problem.
No, I appreciate that. I'm a lawyer. I've dealt with a whole lot of different things, but I go into some of these same issues you just raised, and I'm fortunate that I have brilliant members of the staff who understand it far better than I do. And you feel like sometimes you're chasing something through a maze. But I do appreciate all of you. I will keep the record open for those who wish to add other statements, including the four witnesses. We have another online, and that we'll keep the record open for 10 days for anybody who wants to add further matters or senators who want to. Do we have anything else? Oh, and of course, and I mentioned at the beginning of this, I talked with Senator Tillis just as I was coming over here, and he has really been looking forward to being here and encouraged us to go forward to the hearing just the same. He does have a statement, and of course that'll be put in at the beginning of the hearing. So thank you all very, very much. With that, we'll stand in recess.